Welcome back to SCOTUS Oral Arguments and Opinions. I'm here to deliver a comprehensive look at 5 major Supreme Court decisions all handed down on June 27, 2025. These cases touch on everything from free speech and religious liberty to executive power and constitutional enforcement. If you want to learn more about a specific case, I also released episode-specific opinion summaries. They're a bit lengthy but worth a listen. Okay, let's talk Supreme Court. Please note that this summary is read by an automated voice. June 27, 2025 follows the Supreme Court's well-established pattern of releasing its most consequential decisions in the final days of the term. The court released 5 major opinions that collectively reshape key areas of constitutional law, from how courts can stop government overreach to parents' rights in public schools, from agency power to online speech regulation. Each decision split the court, revealing deep philosophical divisions about the role of government, individual rights, and judicial authority. Notably absent from the day's releases was a decision many court watchers expected: Louisiana versus Callais, case number 24-109. This case involves a complex dispute over Louisiana's congressional redistricting, where the state created a second majority black district, as federal courts demanded under the Voting Rights Act, only to have a different federal court strike down that very map as an unconstitutional racial gerrymander. The court's decision to hold this case for another day suggests the justices may still be grappling with these thorny questions about race, representation, and judicial authority, issues that have divided the court for decades and show no signs of easy resolution. Case 1. Trump versus CASA, the end of universal injunctions. Let's start with perhaps the most immediately impactful decision, Trump versus CASA. This case fundamentally changes how federal courts can respond when the government acts unconstitutionally. The case and key issues. The case arose from 3 separate lawsuits challenging President Trump's executive order attempting to end birthright citizenship, the constitutional principle that anyone born in the United States is automatically a citizen. District courts in multiple jurisdictions issued what lawyers call universal injunctions, court orders that don't just protect the specific people who sued, but block the government from enforcing the policy against anyone anywhere in the country. The core legal question wasn't whether the executive order was constitutional. Instead, the question was whether federal courts have the authority to issue these sweeping, nationwide injunctions at all. The majority opinion, Justice Barrett, writing for 6 justices, said federal courts lack this authority. The majority traced the power of federal courts back to the Judiciary Act of 1789, which gave federal courts the same equitable powers that English courts had at the founding. Barrett's opinion argued that English courts in 1789 didn't issue universal injunctions. They provided relief only to the specific parties before them. The majority distinguished universal injunctions from historical practices like bills of peace, which allowed courts to resolve disputes for entire groups. But Barrett emphasized that bills of peace bound everyone in the group, while universal injunctions only bind the government while leaving affected non-parties without formal legal protection. The concurring opinions. 3 separate concurring opinions revealed different concerns about implementation. Justice Thomas, joined by Justice Gorsuch, warned that courts shouldn't use the complete relief principle as a backdoor way to recreate universal injunctions. Justice Alito, joined by Justice Thomas, worried about 2 potential workarounds: states claiming to sue on behalf of all their residents, and courts hastily certifying nationwide class actions without proper procedural safeguards. Justice Kavanaugh offered perhaps the most practically important concurrence, acknowledging that the decision primarily affects the interim before the interim, the short period before cases reach the Supreme Court. Kavanaugh noted that the Supreme Court itself will likely continue serving as the ultimate decider of whether major federal policies can be enforced nationwide during the often years-long litigation process. The dissenting opinions. The 3 liberal justices filed 2 scathing dissents. Justice Sotomayor, joined by Justices Kagan and Jackson, argued that universal injunctions have deep roots in equity practice and that the majority's historical analysis was flawed. More importantly, Sotomayor warned that the decision creates a zone of lawlessness where the government can violate constitutional rights against anyone who hasn't yet filed a lawsuit. Justice Jackson filed a separate dissent that was even more pointed, arguing that the decision represents an existential threat to the rule of law. Jackson warned that the ruling allows the executive branch to choose law-free action and creates a dual-track system where constitutional protections depend on individual litigation capacity rather than uniform legal standards. Implications. This decision immediately changes how federal litigation works. Plaintiffs challenging government policies will now need to either file class action lawsuits with proper certification procedures or accept that their victories only protect themselves. The decision may encourage more litigation in multiple jurisdictions as different groups seek protection, potentially creating exactly the kind of patchwork enforcement the government often argues is problematic. More fundamentally, the decision shifts power dynamics between the branches. The executive branch gains more flexibility to implement policies, while legal challenges work their way through the courts, while the judiciary loses one of its most powerful tools for checking executive overreach. Case 2. Mahmoud versus Taylor. Parental rights in public schools. Moving from executive power to education, let's examine Mahmoud versus Taylor, a case that significantly expands parental rights in public school settings. The case and key issues. Montgomery County, Maryland introduced LGBTQ-inclusive storybooks into elementary school curricula, initially allowing parents to opt their children out of lessons using these books. When the school board eliminated the opt-out policy, citing classroom disruption, parents from diverse religious backgrounds sued, arguing that forcing their children to hear these stories violated their constitutional right to direct their children's religious upbringing. The legal question centered on whether requiring elementary school students to be exposed to books featuring same-sex marriage and transgender themes without parental opt-outs violates the free exercise clause of the First Amendment. The majority opinion. Justice Alito, writing for 6 justices, held that the parents were entitled to a preliminary injunction requiring the school board to provide advance notice and opt-out opportunities. The majority relied heavily on Wisconsin v. Yoder, the 1972 case that allowed Amish parents to remove their children from high school, but expanded its application significantly. Alito's opinion found that the storybooks created a very real threat of undermining the religious beliefs parents wished to instill in their children. The majority emphasized that the books weren't just exposing children to different ideas, but were unmistakably normative, designed to present certain values as correct and contrary values as wrong. Crucially, the majority rejected the school board's characterization of the curriculum as mere exposure to objectionable ideas, finding instead that the books created psychological pressure on children to conform to specific viewpoints about marriage and gender. The concurring opinion. Justice Thomas wrote separately to emphasize the historical novelty of sexuality and gender education in elementary schools. Thomas noted that sex education is a 20th century innovation and that teaching sexuality and gender identity to very young children is even more recent. Thomas also warned against attempts to weave religiously offensive material throughout the curriculum to make accommodations more difficult. The dissenting opinion. Justice Sotomayor, joined by Justices Kagan and Jackson, argued that the majority had invented a new constitutional right to avoid exposure to ideas that conflict with religious beliefs. Sotomayor emphasized that mere exposure to objectionable ideas has never been sufficient to establish a free exercise violation, and that robust democracy requires citizens to encounter views they might find disagreeable. Sotomayor warned that the decision would impose impossible administrative burdens on schools and hand parents, veto power over countless curricular and administrative decisions. The dissent included a 25-page appendix with pictures from one of the contested books to illustrate the relatively mild nature of the content. Implications. This decision potentially transforms public education by expanding the circumstances under which parents can claim constitutional violations based on school curricula. The majority's fact-intensive test provides limited guidance, but the underlying principle could extend beyond LGBTQ-inclusive materials to other areas where religious objections arise. School districts may face difficult choices between removing potentially controversial materials and managing individualized opt-out requests across diverse religious communities. The decision may encourage more litigation challenging various aspects of public school curricula, while also potentially strengthening arguments for school choice policies. Case 3. FCC versus Consumers Research, Agency Power and the Non-Delegation Doctrine. Our third case takes us into the complex world of agency authority and congressional delegation of power. The case and key issues. The Federal Communications Commission operates the Universal Service Fund, which subsidizes telecommunication services for rural areas, low-income consumers, schools, libraries, and hospitals. The FCC funds this program by essentially taxing telecommunications carriers, currently at nearly 37% of their interstate revenue, with costs passed on to consumers. Consumers Research challenged this system, arguing that Congress impermissibly delegated its taxing power to the FCC without setting specific rates or caps. The case centered on whether Section 254 of the Communications Act violates the Constitution's non-delegation doctrine, which limits Congress's ability to transfer its legislative powers to executive agencies. The majority opinion. Justice Kagan, writing for 6 justices, upheld the FCC's authority using the long-standing intelligible principle test. The majority found that Section 254's requirement that contributions be sufficient to support universal service, combined with detailed statutory criteria defining eligible services and beneficiaries, provided adequate guidance to constrain agency discretion. Kagan rejected the argument that tax statutes require special non-delegation rules with numeric caps or fixed rates. The majority emphasized that the sufficiency requirement creates both a floor and ceiling. The FCCC cannot raise less than necessary or more than adequate to finance universal service programs. The concurring opinions. Justice Kavanaugh's concurrence, while joining the majority, raised significant concerns about congressional delegations to independent agencies. Kavanaugh argued that such delegations raise substantial questions under Article 2 because they lack democratic accountability. However, Kavanaugh concluded that the FCC isn't truly independent because commissioners lack for-cause removal protection. Justice Jackson's concurrence expressed skepticism about the private non-delegation doctrine, which limits government delegation of authority to private actors. The dissenting opinion? Justice Gorsuch, joined by Justices Thomas and Alito, argued that Congress has never before permitted an executive agency to set domestic tax rates without legislative specification. Gorsuch emphasized that the FCC's tax rate has grown from less than 4% in 1998 to nearly 37% today, all without congressional action. Remarkably, Gorsuch noted that even the majority couldn't defend certain provisions of the Universal Service Statute, with the court disclaiming any ruling on sections that allow the FCC to fund additional and advanced services with even less constraint. Implications. The decision maintains the status quo for agency authority while revealing growing tensions within the court about the scope of permissible congressional delegation. The majority's reluctance to address the most problematic provisions suggests future challenges may find more receptive audiences. Justice Kavanaugh's focus on independent agencies signals potential future restrictions on agencies insulated from presidential control, while Justice Gorsuch's dissent demonstrates continued appetite for more robust non-delegation enforcement. Case 4. Kennedy v. Braidwood Management, the Appointments Clause and Healthcare Policy. Moving to our fourth case, Kennedy v. Braidwood Management involves the constitutional structure of federal health policy making. The case and key issues. The case challenged the appointment structure of the U.S. Preventive Services Task Force, which issues healthcare coverage recommendations that became legally binding under the Affordable Care Act. Businesses argued that task force members are principal officers who must be appointed by the President with Senate confirmation rather than by the Secretary of Health and Human Services. The constitutional question centered on whether task force members are principal officers requiring presidential appointment and Senate confirmation, or inferior officers who can be appointed by department heads. The majority opinion. Justice Kavanaugh, writing for 6 justices, held that task force members are inferior officers whose appointment by the HHS Secretary is constitutional. The majority found that the Secretary has sufficient supervisory authority through 2 mechanisms: the power to remove task force members at will, and statutory authority to review and block recommendations before they take effect. Kavanaugh emphasized that the Secretary can prevent task force recommendations from becoming binding during the mandatory 1-year review period, ensuring that members have no power to render a final decision on behalf of the United States unless permitted to do so by the Secretary. The dissenting opinion. Justice Thomas, joined by Justices Alito and Gorsuch, argued that Congress never explicitly vested appointment power in the Secretary. Thomas criticized the majority's complex 2-step statutory interpretation, combining a 1999 provision allowing the agency director to convene the task force with a 1966 reorganization plan transferring functions to the Secretary. Thomas argued that the majority's interpretation makes hash of Congress's design by converting an independent agency answering directly to the President into one subordinate to the HHS Secretary. Implications. The decision clarifies the chain of accountability for consequential healthcare recommendations while potentially strengthening executive control over administrative bodies with significant regulatory impact. However, the disagreement over statutory interpretation methods may influence future appointment authority disputes. The decision leaves broader questions about congressional authority to structure expertise-driven agencies within constitutional constraints, largely unresolved. Case 5. Free Speech Coalition versus Paxton, Online Speech and Age Verification. Our final case addresses the intersection of free speech, technology, and protecting children online. The case and key issues. Texas enacted a law requiring pornographic websites to verify that visitors are 18 or older before allowing access to sexually explicit content. The law applies to websites where more than 1/3 of content is sexually explicit material that is obscene to minors but protected for adults. The Free Speech Coalition challenged the law, arguing that age verification requirements violate the First Amendment by burdening adults' access to protected speech. The majority opinion? Justice Thomas, writing for 6 justices, upheld the Texas law under intermediate scrutiny rather than the strict scrutiny applied in previous similar cases. The majority found that age verification requirements create only an incidental burden on protected speech because they are ordinary and appropriate means of enforcing age-based restrictions. Thomas distinguished the case from previous decisions that struck down laws banning both minors and adults from accessing sexually explicit content. Here, Texas only required age verification. Adults retained full access to the material after proving their age. The dissenting opinion, Justice Kagan, joined by Justices Sotomayor and Jackson, argued that 4 previous Supreme Court cases consistently applied strict scrutiny to content-based restrictions on adult access to sexually explicit speech. Kagan emphasized that the law burdens protected speech based on its content and creates a chilling effect by requiring users to identify themselves to access potentially embarrassing material. Kagan warned that the majority's approach creates special for the occasion, difficult to decipher rules that depart from established First Amendment principles. Implications. The decision provides states with greater flexibility to implement age verification requirements for online content without meeting strict scrutiny's demanding standards. However, the dissent's critique suggests continued uncertainty in this area of law. The practical implications remain mixed, as the court acknowledged that some age verification requirements could still fail constitutional review, while the emphasis on traditional practices highlights ongoing tension between established regulatory approaches and evolving digital realities. Conclusion: understanding the broader patterns. As we step back and look at these 5 decisions together, several patterns emerge that reveal important insights about the current Supreme Court and the direction of constitutional law. First, there's a clear emphasis on historical practices and original understanding across multiple cases. Whether examining 18th century English equity practice in Trump versus CASA, the historical novelty of elementary school sex education in Mahmoud versus Taylor, or traditional age verification methods in Free Speech Coalition versus Paxton, the majority consistently looked to founding-era practices to determine modern constitutional boundaries. Second, these decisions reveal ongoing tensions about the proper role of federal courts in checking government power. The elimination of universal injunctions in Trump versus CASA reduces judicial authority to halt government policies, while the expansion of parental rights in Mahmoud versus Taylor increases judicial oversight of local school decisions. These seemingly contradictory approaches reflect different views about when and how courts should intervene in governmental decision-making. Third, the decisions show the court grappling with how to structure accountability in the modern administrative state. From the FCC's taxing authority to the task force's appointment structure, the court is working to ensure that significant government powers remain subject to democratic control, even as the complexity of modern governance requires specialized expertise. Finally, these cases highlight the court's struggle to adapt constitutional principles developed in the 18th and 19th centuries to 21st century realities. Whether dealing with internet speech regulation, modern educational practices, or the scope of federal agency authority, the justices are working to apply enduring constitutional principles to circumstances the founders could never have imagined. The 6-3 splits in most of these cases, with the same conservative majority prevailing in each, suggest that these divisions reflect deep philosophical differences about constitutional interpretation, the role of government, and the balance between individual rights and collective governance. These differences will likely continue to shape American law and policy for years to come. What makes these decisions particularly significant is that they don't just resolve individual legal disputes, they establish frameworks that will influence countless future cases. From how parents can challenge school curricula to how courts can respond to government overreach, from how agencies can exercise delegated authority to how states can regulate online content, These decisions provide the legal foundation for ongoing debates about the proper scope and limits of government power in America. The real test of these decisions will come in their implementation. Will lower courts faithfully apply the new restrictions on universal injunctions? Will school districts find workable ways to accommodate religious objections while maintaining educational coherence? Will agencies adapt their practices to comply with evolving non-delegation requirements? Will states successfully implement age verification systems that pass constitutional muster? These questions will be answered in the months and years ahead as these Supreme Court decisions work their way through the broader legal system and into the daily operations of government at every level. What's certain is that June 27, 2025 will be remembered as a day when the Supreme Court made fundamental changes to how constitutional law operates in America. Thanks for joining me for this comprehensive look at 5 major Supreme Court decisions. These cases will undoubtedly generate continued discussion and analysis as their implications become clearer. I'll be back soon with more Supreme Court coverage as we continue to track how these decisions shape law and governance. If you found this analysis helpful, please subscribe and share with anyone interested in understanding how the court really shapes our lives. Talk to you soon.